EGM Network.
Hi, welcome to Silver Linings. Today is going to be a little different. Raul and I are going to play a bit of a game in hopes to educate while having fun and maybe creating a little bit of laughter. If you don't know me, I'm Janine Barrows, and I am a co-host here with Raul Perez, and we thought that we'd shift it up. So we're going to play an opportunity in a game to see if we can stump Raul a little bit. You know, attorneys are pretty on their game, so how you feel about that, Raul?
Good. I mean, we'll see how this turns out at the end, but let's see what the first question looks like, and that'll determine how things go.
Okay. All right. So we'll try and keep it somewhat simple in the beginning. Often when I meet with people and they're like, hey, I got to go see an attorney, they have no idea about terminology, what kind of attorney they need to go see, if that attorney's credible, all that good stuff. But the biggest factor that I see is it's outside of our comfort zone if we're not attorneys and we don't work in the legal system. So everything seems really bizarre and really complicated and super expensive, probably. But the biggest part is we don't have the knowledge, right? And it doesn't all have to be hard and scary. And so today I'm thinking we're going to have a little fun, right?
All right, let's do it.
And notice we're quizzing him, not me. Okay, so can we talk about 7 factors of undue influence that can be used to challenge a will?
Okay, so the undue influence itself is when you have a will and someone is trying to object to the validity of the will. And these are 7 factors that can be used to show that there's a problem. Because normally when we have undue influence, it's not obvious. It's not something that can be seen because it's done behind closed doors. Okay. So these are some of the factors that we look to show that there is the presumption of something inappropriate going on. Okay. So some of those things that we look at is, did the person have knowledge of what was going into the will before its execution? Were they present at the execution of the will? Did they direct the attorney who was creating the will with what to put in the will? Did they get the witnesses to be a part of the will themselves? Did they safekeep the will after it was executed? One of them is very similar to the others, but were they present when the testor expressed his desires of what he wanted to put into the will? I don't remember if that's 6 or 7.
All right. Well, that was nice. Layman's terms. Those are kind of a way for me to understand it. Was English. I understood all of what you were saying. But just for the purpose of our audience, I want them to hear what it looks like in print. So it says, and correct me, what is the benefactor present when testator expresses desire to create a will? Right. 2, I'm assuming this is benefactor, right? Okay. Benny recommends attorney to draft will.
So beneficiary, who would
beneficiary, okay. Beneficiary present when testator expresses desire to create a will. Beneficiary recommends attorney to draft will.
That's the one I missed. There you go.
Benny
the recommendation
provides info to attorney to draft will. Benny knowledge of will contents before execution. Benny present at execution of will. Benny secures witness to will, and Benny secures will after execution. Now, what you said versus what that reads sounds very different.
So the
common terms make a huge difference for most of us to comprehend what's going on.
Right. So sometimes I have clients that come in and they want to understand how they look at a will and they say, well, this is not, mom would have never done this, right? Mom, that's not what mom wanted. And then I'd have to go through the factors and try to say, okay, look, the likelihood is you were not there when this was done, right? Mm-hmm. Probably the only people that were there when this was done was your mom, the sister who was going to be the beneficiary, and maybe one other party or witnesses to this. And they would know, they would be the witnesses to the case that you would have to call. This is normally done behind closed doors, and there's not much information that's available. So this was formulated in a case called Carpenter v. Carpenter, laying the groundwork for what are some things that someone challenging a will could look towards and point to so that they have a shot at the case. So in this particular case, you're just raising the presumption, right? You're raising the presumption if you can at least find 3 or maybe 4 of these. And what that does is it shifts the burden to the other party to say, okay, this is the reason why, although it may look like there's a problem, there really isn't.
All right.
So it's a back and forth type of case.
Now that brings into play something else. So let's try some other definitions and let's see if you can clarify it for our listeners.
Okay.
So the presumption of undue influence when creating a will is important. Why? And what does that mean?
So the presumption of undue influence, the definition itself, you would have to, so it only comes into a case where we have a substantial beneficiary who has a confidential relationship with the testor, and you can show that there's some form of active procurement.
That is almost exactly word for word. And for the record, he doesn't know what I'm asking or what my answers are. That's awesome.
And just so that, so that you understand where these 7 factors come from, the act of procurement is where those 7 factors live. So these are actually 3 elements. There's 3 elements to undue influence, which is the substantial beneficiary, the confidential relationship, and act of procurement is a 3rd element. And within that 3rd element, you find these 7 factors. And there are more that we point to, which can be shown. For example, isolation is one, which is normally common when someone at the end of life makes a will close to their date of death, or the mental inequality between the beneficiary doing the undue influence and the testator. And one last one that we look at is what is the reasonableness of the changes to the will. So those are other factors that we can look at because it's not an exclusive list. You can go outside of the 7.
All right. Okay. So they tie these two topics and definitions kind of tie together. One needs the support of the other to be valid, right?
Yes.
Okay. That's pretty cool. So I have one. What is the preference and appointment of is it a personal, what is a PR testate?
Okay. So PR stands for personal representative.
That's what I thought. Okay.
And testate is, it's a probate that has a will. If it's a probate without a will, it's called intestate.
Okay.
And as far as preference, when there is a will, so in the will itself, there should be a section which appoints a personal representative. So whoever's nominated as personal representative has preference and appointment first. If there is nobody left on that list, or there is not a list of names, then you go to the majority in interest get to pick. So if there's 3 beneficiaries and 2 of them say, I want this one person, that's the person who's going to be elected. Okay. There's more that go down the list. At the end, the judge can appoint whoever he sees fit because these are just preferences. So if there's an argument, the judge can go ahead and say, here's who we're going to choose.
All right, that's awesome because on my paperwork, it says that PR has to be named in the will, just like you said, or they have to be chosen by the majority of the beneficiaries, excuse me. And any devicee, if there's an issue, the court may select a best qualified. So if the family can't come up with somebody, then the court can intervene and assign somebody to be that individual.
Right.
Okay. All right. You're batting great. All right. All right. Okay. So, who can't be a personal representative?
So, someone who is under 18 cannot be personal representative.
No minors.
You could not have committed a felony. Okay. So that's an absolute bar. Okay. Right. I did have a case where someone had their rights restored. So you are able to apply at that point, but the judge has to make the decision. You cannot, and this is newer in the law, but you could not have committed some type of an abuse of the elderly, and that would prevent you from being personal representative. And what was the question again? Who is not allowed to be personal representative? Okay, so so there is another rule where if a Florida resident in any probate case can be a personal representative, okay? However, if my father, for example, if my father passed away and he named a friend that now lives in Tennessee, and that's what it wrote in his will, that friend cannot serve. Okay. So they have to be a Florida resident or somehow biologically a lineal descendant has to be appointed. So it could be a cousin, a second cousin, an aunt, a niece, a nephew.
They could be out of state.
And they can be out of state.
If they are not blood related, they have to be within the state that the individual is in when they pass or when their documents are.
Yes.
Okay. All right. All right. That's pretty good. I like that you're on target with these as well. All right. So we're not stumping him yet. Let's see here. I'm going to move that one. All right. What is a grantor trust rule?
Okay. When it comes to grantor trusts, you have a trust that obviously all trusts are created by a grantor. Okay, the grantor is the person who creates the trust. It's in a will we call them the testators. In trust we call them grantors, settlors, trustors, which we don't really use too much. But as far as a grantor trust, it's a trust that's created for the benefit of beneficiaries, but it can be the terminology is that it can be assets are counted against the grantor when it comes to tax purposes.
Okay. All right. All right. That seems a really in-depth question. You gave us a pretty good succinct answer, which is awesome because I think if we had to read all of these breakdowns, we'd be really confused. So I'm saying you're batting 100% right now, Raul. I'm pretty impressed. I thought I was going to stump you with some random. I even used the AI chat Quizlet.
Okay.
So hold that thought because we're going to go on for our break. We easily get caught up in these topics and we're just trying to simplify them for you today. But we want to take a minute for our commercial supporters. We'll be back shortly.
Happy 100th, Indian River. It's the Downtown Centennial Celebration presented by GHO Homes. We're lighting up downtown Vero with a free street party with live music by Mighty Flea Circus, plus a parade at 7, kids games, beer, and food trucks. Be ready to dance from 6 to 10. Admissions free. Sponsored by GHO Homes, Wire 3, and Mangrove Sands Golf Club and Restaurant. The Downtown Centennial Celebration, a Main Street Vero Beach event, Friday, June 27th at 6 p.m. in downtown Vero Beach.
It's time to call Easy Brew Coffee and Bottled Water Service and learn just how much you can save and how convenient it is to have your coffee and bottled water delivered right to your home or office. In addition to water coolers, Easy Brew offers individual bottles of water in 8 or 16-ounce bottles. No more lugging it home or dragging it into the office. Serving the Treasure Coast for over 2 decades, 2 letters, 1 simple name. Easy for Easy Brew. Visit e-zbrew.com or call 800-792-3285. Easy Brew.
Welcome back. It's always painless, but more so with gratitude that we get to have our commercial sponsors come on. Not only do we have these great commercial sponsors, but we actually have our show sponsor. And I would be remiss without screaming out to the team at Dill, Evans, and Rotoback for their support. And if you or loved ones find yourself in need for any kind of services pertaining to elder law, family law, estate, and trust law, please don't hesitate. Reach out to them. They are amazing with over 30 years here in Sebastian and on the Treasure Coast. So back to our topic. Before we jump into some of scenario stories and breaking that down, you said you had a question you were going to pose to me.
So you started out by saying, well, some people come in and they think they know what's going on, and that's why it's probably better to talk to an attorney.
Correct.
So I'll give you a scenario, and you tell me what you think would happen, and then I can let you know whether that's true or not.
All right.
And I'll try to keep it simple.
Okay.
So we have mom, dad's already deceased.
Okay.
Mom has 4 children.
Mm-hmm.
In this scenario, one of the children has predeceased mom, so she died before.
Okay.
That child had 2 of his own children. So now we have mom, 3 children, and 2 grandchildren. How would the estate be distributed in intestate?
Okay. Intestate means in the will.
Intestate means no will.
No will. And mom is gonna pass.
Mom passes, and at the end of the day, there are 3 out of 4 kids alive.
3 adult children of the 4 and 2 grandchildren of the predeceased
Yes.
child.
So how is it split up?
Well, if I was just thinking common sense, conversing with my family,
Exactly.
I would say if there was no will, that assets would be put in probate, which most of us don't even understand what that means. And I'm a little sketchy on the definition, but I think it's something I've heard enough that I would think they would have to do that without will, because that's what you hear.
Of course.
And that the 3 children would be the immediate descendants to mom that were alive would then be allocated in some way to have voice and or split said assets once probate pulls everything together to define value.
What do you think about the grandkids? Would the grandkids get anything in this scenario?
I don't think so, unless mom had said, I want all 4 of my kids to receive equally, and then if they're not there, their children would receive their portion. I mean, logically, I'm sure they loved her grandchildren.
I'm going to go ahead and stop you there.
All
okay.
right.
So you did a good analysis, right, of kind of thinking through it. Now, that's why it's important to do a will, right? You basically just said what you would do in a will, right? She should lay out who should get this.
Right.
Because if not, we have to fall to the state statute. And the state statute in intestate says there's a whole linear line. But basically, if there is no spouse, then to the children, equally. But not only to the children, but to the descendants of a deceased child. So in this particular case,
So they are?
each child would get 25%, and the 2 grandchildren would get their father or mother's 25% to split amongst themselves. So that's what would happen in intestate if there were 4 children with 3 who were alive, 1 deceased, and they have children. If the deceased child did not have any children, then you are right. It would be split amongst the 3. Because there's no other descendants of that line. So these are the type of questions where someone who doesn't know will come and we will say, okay, let's draw it out. Who's alive? Who's not alive? Who's there? Who do we have? It's important because we have had cases where, and that's why the first thing I mentioned is, do we have any deceased children? Because people don't think they count, right? People don't think they count. You don't think about it. We had a case where there was 6 children, 4 deceased, but all 4 of them had children. They never told us, and now we have to come back and say, all right, let's fix this, because there's more than just 2 beneficiaries. There's really 9. So that's why it's important when a client comes in to ask the right questions so we know what we're dealing with and we don't get any surprises on the back end.
Oh, look, you just stumped me. I'm supposed to be stumping you.
Well, then I'll give you one more.
Oh, okay. All right. All right.
Okay.
At the risk of educating our followers.
Okay. So same scenario. Okay. Mom's alive, dad's gone. Mom passes away, all 4 children are alive. 60 days after mom dies, one of the children dies. How is the estate split?
There's something to do with the 60 days, I'm sure. I mean, it would make sense that logically, based on our prior conversation, that then that past child would be able to have their children maybe be considered. But if it happened after afterward. No, clarify, because
Okay.
that's a little deep.
Okay. So whether they have children, whether that deceased brother or sister had children or not, what would happen in that case is you would have to do mom's probate, divide it 25% to each person, even the one that is now dead after the fact, because now you have to deposit it into their estate.
To their estate.
Their estate. And the reason being is that child had creditors of their own, beneficiaries of their own. So we can't just skip that line and go to somewhere else. So we have to give that son his portion to be dealt with in his estate so that his beneficiaries can then take.
So what is the verbiage you specifically used about 60 days? Is there a time frame where, say, a probate, you've heard about probate sometimes lasting a fairly long period of time. I don't know how long is the max allowance for a probate to go on or something like that. Why did you specify 60? Was it just pulled out of your pocket? Is there a reason?
I specify 60 days because when we do a will, normally most attorneys include a clause in there where it's a survivorship clause. And the one that we normally use is a 30-day clause, where if any beneficiary does not outlive the testator by 30 days, we're going to presume that they predeceased us. That would avoid, in some cases, having to do an extra probate. So I only mentioned 60 days because I'm so used to this topic that I picked that number because I know I'm reflecting back on wills that I have done.
Okay.
But that provision could be extended to 60, 90 days. The testator is the person who controls what happens with their estate. There can even be a provision which normally they're reserved for trusts, but there are provisions that say, I intend these to be my beneficiaries, but they will only receive if they are still alive when we're done and ready to distribute. So there are scenarios where if the 4 children were there and one passed away and they were no longer there, that the 3 could still get it completely, depending on the terms of the will. That's why creating a will or a trust is so important, because you can dictate almost to the infinite degree of how you want your estate to be distributed and who you want it to be distributed to and how you want it to be distributed and when. So you can have control over where those assets lie, who's going to get them and how, which is important to some people because we don't know when we're going to pass away and who the beneficiaries and how they're going to be at that time. So a will can help, or a trust can help control that.
Huh. All right. So we've talked about some definitions and some clarity and some common terms, and we only have a few minutes left. So I just want to ask real quick and see what you think about this. Okay. I'm going to go back here. Gloria, a resident of State X, executes an oral will which complies with all State X formalities. Several years later, Gloria moves to Florida. When Gloria dies, her will A, be admitted into probate since it was properly executed in State X. B, be admitted into probate since Florida recognizes non-cupative wills. C, will not be admitted into probate since Florida does not recognize non-cupative wills. Or D, will not be admitted into probate because that was not executed in Florida. What is the answer, my friend?
Those definitions were a little bit long, but an oral will is not recognized in Florida. Neither is a holographic will. So because it doesn't follow state statutes, we will not recognize it.
Ding, ding, you're right. It says will not be admitted into probate since Florida does not recognize non-cupative wills. You know, and that rounds us back to the importance of why we're having these conversations today. It sounds cute and glitchy and we're trying to stump you, but what's the message? The message is go to an attorney, get your ducks in a row, meet with a team like Raul and his, because you don't want to be sitting during the hardest days of your life trying to pick through the haystack for that needle. They will do that work for you. They will make it ahead of time, and they will ensure that you and your family have time to mourn, rather than running around trying to figure out the answers or solutions to problems that you shouldn't have to be dealing with at that time. Raul, thank you so much for sharing with us, playing a little game, kind of exposing yourself. I'm sure you're like, whoo, I'm glad she didn't get me on anything.
Right.
And we hope to see you next week with our guests in place. Thank you so much for being part of Silver Linings. If you have any questions or concerns, please reach out to the team at Dill, Evans, and Rodeback and Sebastian. With over 30 years of experience, they really are your go-to for elder care law and trust services, not to mention estate law. So thank you so much. Have a great night.